Chapter 2 of Contracts, Voidable Contracts, and Void Agreements. Section 10. What agreements are contracts? All agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object and are not hereby expressly declared to be void. Nothing herein contained shall affect any law in force in India and not hereby expressly repealed, by which any contract is required to be made in writing or in the presence of witness, or any law relating to the registration of documents. Section 11. Who are competent to contract? Every person is competent to contract who is of age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. Section 12. What is a sound mind for the purposes of contracting? A person is said to be of sound mind for the purpose of making a contract if at the time when he makes it, he is capable of understanding it and of forming a rational judgment as to its effect upon his interest. A person who is usually of unsound mind but occasionally of sound mind may make a contract when he is of sound mind. A person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of unsound mind. Illustrations. A. Uh, a patient in a lunatic asylum who is at intervals of sound mind may contract during those intervals. B. A sane man who is delirious from fever or who is so drunk that he cannot understand the terms of contract or form a rational judgment as to its effect on his interests cannot contract whilst such delirium or drunkenness lasts. Okay. Section 13. Consent defined. Two or more persons are said to consent when they agree upon the same thing in the same sense. 14. Free consent defined. Consent is said to be free when it is not caused by 1. Coercion as defined in section 15, or undue influence as defined in section 16, or third, fraud as defined in section 17, or fourth, misrepresentation as defined in section 18, or fifth, mistake subject to the provision of sections 20, 21 and 22. Consent is said to be so caused when it would not have been given but for the existence of such coercion, undue influence, fraud, misrepresentation, or mistake. 15. Coercion defined. Coercion is committing or threatening to commit any act forbidden by the Indian Penal Code 45 of 1860, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, within the intention of causing any person to enter into an agreement. Explanation. It is immaterial whether the Indian Penal Code 45 1860 is or is not in force in the place where the coercion is employed. Illustration. A. On board an English ship on the high seas causes B to enter into an agreement by an act amounting to criminal intimidation under the Indian Penal Code. A afterwards sues B for breach of contract at Calcutta. A has employed coercion although His act is not an offence by the law of England. And although Section 506 of the Indian Penal Code was not in force at time when or place where the act was done. Okay. Section 16. Undue influence defined. 1. A contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. Second, in particular or without prejudice to the generality of the foregoing principle, a person is deemed to be in a position to dominate the will of another. A. Where he holds a real or apparent authority over the other, or where he stands in a fiduciary relation to the other, or B. Where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reason of age, illness, or mental or bodily distress. Third, where a person who is in position to dominate the will of another enters into contract with him and transaction appears on the face of it or on the evidence adduced to be unconscionable, the burden of proving that such contract was not induced by undue influence shall lie upon the person in a position to dominate the will of the other. Nothing in this subsection shall affect the provision of section 111 of the Indian Evidence Act 1872. Illustrations. A. Okay, first, A having advanced money to his son. B. During his minority, upon B's coming of age, obtains by misuse of parental influence a bond from B for a greater amount than the sum due in respect of the advance. A employs undue influence. Second one, a man enfeebled by disease or age is induced by B's influence over him as his medical attendant to agree to pay B an unreasonable sum for his professional services. B employs undue influence. Third, A, being in debt to B, a moneylender of his village, contracts a fresh loan on terms which appears to be unconscionable. It lies on B to prove that the contract was not induced by undue influence. Fourth, A applies to a banker for a loan at a time when there is a stringency in the money market. The banker declines to make the loan except at an unusually high rate of interest. A accepts the loan on these terms. This is a transaction in the ordinary course of business and the contract is not induced by undue influence. Section 17. Fraud defined. Fraud means and includes any of the following acts committed by a party to a contract or with his connivance connivance or with his connivance or his agent with intent to deceive another party thereto of his agent, or to induce him to enter into the contract. First, the suggestion as a fact of that which is not true by one who does not believe it to be true. Second, the active concealment of a fact by one having knowledge or belief of the fact. Third, a promise made without any intention of performing it. Fourth, any other act fitted to deceive. Fifth, any such act or omission as the law specially declares to be fraudulent. Explanation: mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud, unless the circumstances of the case are such that regard being had to them, it is the duty of the person keeping silence to speak, or unless his silence is in itself equivalent to speech. Illustrations: 1. A sells by auction B a horse which A knows to be unsound. A says nothing to B about the horse. Horse is unsoundness. Horse's unsoundness. This is not fraud in A. Second one, B is A's daughter and had just come of age. Here, the relation between the parties would make it A's duty to tell B if the horse is unsound. Third, B says to A, if you do not deny it, I shall assume that the horse is sound. A says nothing. Here, A's silence is equivalent to speech. Fourth, A and B, being traders, enter upon a contract. A has private information of a change in prices which would affect B's willingness to proceed with the contract. A is not bound to inform B. Section 18. Misrepresentation defined. Misrepresentation means and includes: first, the positive assertion. First, the positive assertion in a manner not warranted by the information of the person making it of that which is not true, though he believes it to be true. Second, any breach of duty which, without an intent to deceive, gains an advantage to the person committing it, or anyone claiming under him by misleading another to his prejudice, or to the prejudice of anyone claiming under him. Third, causing, however innocently, a party to an agreement to make a mistake as to the substance of the thing which is the subject of the agreement. 19. Voidability of agreements without free consent. When consent to an agreement is caused by coercion, fraud, or misrepresentation, the agreement is a contract voidable at the option of the party whose consent was so caused. A party to a contract whose consent was caused by fraud or misrepresentation may, if he thinks fit, insist that the contract shall be performed, that he shall be put in the position in which he would have been if the representation made had been true. Exception: if such consent was caused by misrepresentation or by silence fraudulent within the meaning of section 17, the contract nevertheless is not voidable if the party whose consent was so caused had the means of discovering the truth with ordinary diligence. Explanation: a fraud or misrepresentation which did not cause the consent to a contract of the party on whom such fraud was practiced, or to whom such misrepresentation was made, does not render a contract voidable. Illustrations: first, A intending to deceive B falsely represents that 500 mounds of indigo are made annually at A's factory, and thereby Induce B induces B to buy the factory. The contract is voidable at the option of B. Second one, A by misrepresentation leads B erroneously to believe that 500 mounts of indigo are made annually at A's factory. B examines the account of the factory which shows that only 400 mounts of indigo have been made. After this, B buys the factory. The contract is not voidable on account of A's misrepresentation. C. Third one. A fraudulently informs B that A's estate is free from encumbrance. B thereupon buys the estate. The estate is subject to a mortgage. B may either avoid the contract or may insist on its being carried out and the mortgage debt redeem. D, fourth one, in that B, having discovered a ven or ore on the estate of A, adopts means to conceal and does conceal the existence of the ore from A. Through A's ignorance, B is enabled to buy the estate at an undervalue. The contract is voidable at the option of A. E. A is entitled to succeed to an estate at the death of B and B dies. A is entitled to succeed to an estate at the death of B and B dies. C, having received intelligence of B's death, prevents the intelligence reaching A and thus induces A to sell him his interest in the estate. The sale is voidable at the option of A. Okay. Power to set aside contract induced by undue influence. When consent to an agreement is caused by undue influence, the agreement is a contract voidable at the option of the parties whose consent was so caused. Any such contract may be set aside either absolutely or if the party who was entitled to avoid it has received any benefit thereunder upon such terms and conditions as to the court may seem just. Illustration. First, A's son has forged B's name to a promissory note. B, under threat of prosecuting A's son, obtain a bond from A for the amount of the forged note. If B sues on his bond, the court may set the bond aside. Second one, a money lender advances rupees 100 to B, an agriculturist, and by undue influence induces B to execute a bond for rupees 200 with interest at 6% per month. The court may set the bond aside, ordering B to repay the rupees 100 with such interest as may seem just. 20. Section 20. Agreement void where both parties are under mistake as to matter of fact. Agreement void where both parties are under mistake as to matter of fact. Okay. Where both the parties to an agreement are under mistake as to a matter of fact essential to the agreement is void. Explanation and erroneous opinion as to the value of the thing which forms the subject matter of the agreement is not to be deemed a mistake as to matter of fact. Illustrations. First, A agrees to sell to B a specific cargo of goods supposed to be on its way from England to Bombay. It turns out that before the day of the bargain, the ship conveying the cargo had been cast away and the goods lost. Neither party was aware of these facts. The agreement is void. A agrees to buy from B a certain horse. It turns out that the horse was dead at the time of bargain, though neither party was aware of the fact the agreement is void. Third, A, being entitled to an estate for the life of B, agrees to sell it to C. B was dead at the time of the agreement, but both parties were ignorant of the fact the agreement is void. Section 21. Effect of mistakes as to law. A contract is not voidable because it was caused by a mistake as to any law in force in India, but a mistake as to law not in force in India has the same effect as mistake of fact. Okay. Illustration. A and B make a contract grounded on the erroneous belief that a particular debt is barred by the Indian law of limitation. The contract is not voidable. Section 22. Contract caused by mistake of one party as to matter of fact. Contract caused by mistake of one party as to matter of fact. Okay. A contract is not voidable merely because it was caused by one of the parties to it being under mistake as to matter of fact. Okay. Section 23. What considerations and objects are lawful and what not? Section 23. What considerations and objects are lawful and what not? Okay. The consideration or object of an agreement is lawful unless it is forbidden by law or is of such a nature that if permitted it would defeat the provisions of any law, or is fraudulent, or involves or implies injury to the person or property of another, or the court regards it as immoral or opposed to public policy. In each of these cases, the consideration or object of an agreement is said to be unlawful. Every agreement of which the object or consideration is unlawful is void. Illustrations. A. First one. A agrees to sell his house to B for 10,000 rupees. Here, B's promise to pay the sum of 10,000 rupees is the consideration for A's promise to sell the house, and A's promise to sell the house is the consideration for B's promise to pay 100,000 rupees. These are lawful considerations. Second one, A promises to be 1,000 rupees at the end of the 6 months. If C, who owes that sum to B, fails to pay it, B promises to grant time to C accordingly. Here, the promise of each party is the consideration for the promise of the other party, and they are lawful considerations. Third, A promises for a certain sum paid to him by B to make good to be the value of his ship if it is wrecked on a certain voyage. Here, A's promise is the consideration for B's payment, and B's payment is the consideration for A's promise, and these are lawful considerations. D. A promises to maintain B's child, and B promises to pay 8,000 rupees yearly for the purpose. Here, the promise of the each party is the consideration for the promise of the other party. They are lawful considerations. A, B, and C enter into an agreement for the division among them of gains acquired or to be acquired by them by fraud. The agreement is void as its object is unlawful. F. A promises to obtain from B an employment in the public service, and B promises to pay 1,000 rupees to A. The agreement is void as the consideration for it is unlawful. G. A, being agent for a landed proprietor, agrees for money without the knowledge of his principal to obtain for B a lease of land belonging to his principal. The agreement between A and B is void, as it implies a fraud by concealment by A on his principal. H. A promises B to drop a prosecution which he has instituted against B for robbery, and B promises to restore the value of the things taken. The agreement is void as its object is unlawful. I. Each estate is sold for areas of revenue under the provision of an act of the legislature by which the defaulter is prohibited from purchasing the estate. B is upon an understanding with A becomes the purchaser and agrees to convey the estate to A upon receiving from him the price which B has paid. The agreement is void as it renders the transaction in effect a purchase by the defaulter and would so defeat the object of the law. J. A, who is B's Mukhtar, promises to exercise his influence as such with B in favor of C, and C promises to pay 1,000 rupees to A. The agreement is void because it is immoral. K. A agrees to let her daughter to hire to B for concubinage. The agreement is void because it is immoral, though the letting may not be punishable under the Indian Penal Code. 45 of adding 60. Next is void agreements. 24. Section 24. Agreement void if considerations and object unlawful in part. If any part of a single consideration for one or more object or any part of any one of several considerations for a single object is unlawful, the agreement is void. Illustration. A promises to superintend on behalf of B a legal manufacture of indigo and an illegal traffic in other articles. B promises to pay to A a salary of 1,000 rupees a year. The agreement is void, the object of A's promise and the consideration for B's promise being in part unlawful. Section 25. Agreement without consideration void unless it is in writing and registered or is a promise to compensate for something done or is a promise to pay a debt barred by limitation law. An agreement made without consideration is void unless it is expressed in writing and registered under the law for the time being in force for the registration of documents or and is made on account of natural love and affection between parties standing in a near relation to each other or unless. Second, it is a promise to compensate wholly or in part a person who has already voluntarily done something for the promiser or something which the promiser was legally compellable to do or unless. Third, it is a promise made in writing and signed by the person to be charged therewith or by his agent generally or specially authorized in that behalf to pay wholly or in part a debt of which the creditor might have enforced payment but not for the law for the limitation of suits. In any of these cases, such an agreement is a contract. Explanation 1. Nothing in this section shall affect the validity as between the donor and donee of any gift actually made. Explanation 2. An agreement to which the consent of the promisor is freely given is not void merely because the consideration is inadequate, but the inadequacy of the consideration may be taken into account by the court in determining the question whether the consent of the promisor was freely given. Illustrations. First, A promises for no consideration to give to B rupees 1000. This is a void agreement. A, for natural love and affection, promises to give his son B rupees 1000. A puts his promise to be into writing and register it. This is a contract. A finds B's purse and gives it to him. B promises to give A rupees 50. This is a contract. A supports B's infant son. B promises to pay A's expenses in so doing. This is a contract. E. A owes B rupees 1000 but the debt is barred by the Limitation Act. A signs a written promise to pay B rupees 500 on account of the debt. This is a contract. F. A agrees to sell a horse worth rupees 1000 for rupees 10. A's consent to the agreement was freely given. The agreement is a contract, notwithstanding the inadequacy of the consideration. G. A agrees to sell a horse worth rupees 1000 for rupees 10. A denies that his consent to the agreement was freely given. The inadequacy of the consideration is a fact which the court should take into account in considering whether or not A's consent was freely given. Section 26. Agreement in restraint of marriage. Void. Every agreement in restraint of marriage of any person other than a minor is void. Section 27. Agreement in restraint of trade. Void. Every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. Explanation 1. Saving of agreement not to carry on business of which goodwill is sold. One who sells the goodwill of a business may agree with the buyer to refrain from carrying on a similar business within specified local limits so long as the buyer or any person deriving title to the goodwill from him carries on a like business therein, provided that such limits appear to the court reasonable, regard being had to the nature of the business. Section 28. Agreements in restraint of legal proceedings. Void. Every agreement by which any party thereto is restricted absolutely from enforcing his rights under or in respect of any contract by the usual legal proceeding in the ordinary tribunals, or which limits the time within which he may thus enforce his rights, or B. which extinguishes the right of any party thereto or discharges any party thereto from any liability under or in respect of any contract on the expiry of a specified period so as to restrict any party from enforcing his right. is void to extent. Exception 1, saving of contract to refer to arbitration dispute that may arise. Saving of contract to refer to arbitration dispute that may arise. This section shall not render illegal a contract by which two or more persons agree that any dispute which may arise between them in respect of any subject or class of subjects shall be referred to arbitration, and that only the amount awarded in such arbitration shall be recoverable in respect of the dispute so referred. Exception 2, saving of contract to refer questions that have already arisen. Nor shall this section render illegal any contract in writing by which two or more persons agree to refer to arbitration any question between them which has already arisen, or effect any provision of any law in force for the time being as to references to arbitration. Exception 3, saving of a guarantee agreement of a bank or a financial institution. This section shall not render illegal a contract in writing by which any bank or financial institution stipulate a term in a guarantee or any agreement making a provision for a guarantee for extinguishment of the right or discharge of any party thereto from any liability under or in respect of such a guarantee or agreement on the expiry of a specified period which is not less than 1 year from date of occurring or non-occurring of specified event for extinguishment or discharge of such party from said liability. Explanation for in exception 3, the expression bank means: first, a banking company as defined in clause C of section 5 of the Banking Regulation Act 1949. B, a corresponding new bank as defined in clause D of section 5 of the Banking Regulation. Okay. Section 29. Agreements void for uncertainty. Agreements, the meaning of which is not certain or capable of being made certain, are void. Illustration. First, A agrees to sell B 100 tons of oil. There is nothing whatever to show that kind of oil was intended. The agreement is void for uncertainty. B, E agrees to sell to B 100 tons of oil of specified description, known as an article of commerce. There is no uncertainty here to make the agreement void. C, A, who is a dealer in coconut oil only, agrees to sell B 100 tons of oil. The nature of A's trade affords an indication of the meaning of the words, and A has entered into contract for the sale of 100 tons of coconut oil. D, A agrees to sell to B all the grain in my granary at Ramanagar. There is no uncertainty here to make the agreement void. E, A agrees to sell B 1000 mounds of rice at a price to be fixed by C. As the price is capable of being made certain, there is no uncertainty here to make the agreement void. F, A agrees to sell to B my white horse for rupees 500 or rupees 1000. There is nothing to show which of the two prices was to be given. The agreement is void. Section 30. Agreement by way of which are void. Agreements by way of which are void, and no suit shall be brought for recovering anything alleged to be won on any wager or entrusted to any person to abide the result of any game or other uncertain event on which any wager is made, exception in favor of certain prizes for horse racing. This section shall not be deemed to render unlawful a subscription or contribution or agreement to subscribe or contribute made or entered into for or toward any plate, prize or sum of money of the value or amount of 500 rupees or upward to be awarded to the winner or winners of any horse race. Section 294A of the Indian Penal Code not affected. Nothing in this section shall be deemed to legalize any transaction connected with horse racing to which the provision of section 294A of the Indian Penal Code 45 of 1860 apply.